Hello everyone, picking up from where we stopped last time. Today we're going to look at Freehold, Leasehold and Mailo land tenure system in Uganda. Last tenure system, we looked at the characteristics, what it means. We looked at given legislations and how they affected that kind of tenure system. So there we are going to begin with Freehold. But before, I had a question. We are going to be guided by this question. A and B are desirous of buying land in Uganda. They are disturbed by so many systems. Using the knowledge you have of land law, guide them to make an informed decision highlighting the similarities and differences between the systems as you advise on the best and why. So let's first look at this question. This question requires us to talk about the four tenure systems we have in Uganda. Just like we began last time, you begin with what land is, right? What is land? You can use the Black's Law Dictionary or case law. You can even use a statutory provision, because I think under the Registration of Titles Act it gives us a definition. Then after that, you tell us characteristics of each and every tenure system. Characteristics of each and every tenure system we have in Uganda. For instance, we looked at customary tenure system last time, and we looked at one of the characteristics being it being communal land, in that it's owned by a group of individuals rather than an individual, or a group of people rather than an individual, right? We also looked at given traditions and customs available for such land tenure system, right? So you give us characteristics of each and every tenure system, perhaps the advantages and disadvantages. Then you recommend which one is the best and why. And I would say the best tenure system is Freehold. Reason being, Freehold has got a number of advantages or features, right, as we are going to see in our discussion. So, Freehold tenure system. Let's begin from Freehold tenure system. Freehold tenure system is a system where owners of land have a deed or title to their land, which allows them to hold the registered land forever and do whatever they want with it in accordance with the law. They can use, sell, lease, transfer, subdivide, mortgage, or give away the land as they may deem it fit or they may wish, right? So this simply tells us that if you are owning freehold tenure system or freehold land, you're the owner of that land, you're the registered proprietor of that land. Therefore, you have powers to give it away, sell it, mortgage it, lease it, subdivide it the way you want, because as long as you do that in adherence with the laws governing land we have in Uganda, right? So you have all powers concerning this land, unlike under Mailo and under Mailo tenure and customary or even leasehold, because under leasehold, just like we shall see, you're granted ownership of this land for a given period of time. So this means that you're the owner of that land for till the lapse of the lease agreement or the a given period of time. But freehold, perpetuity, you're there for perpetuity. It's you who knows what you want to use that land for. Right? So land registration regarding freehold is governed by the Registration of Titles Act. That's why we are not going to talk about a lot concerning freehold and leasehold tenure systems. Big reason being, you're going to look at these tenure systems in depth when you're looking at land transactions, which you're yet to do next semester. Right? Anyways, let's look at the features of land of freehold tenure system. The holder owns a certificate of title describing the land. Please note that here under freehold, the holder or the owner holds a certificate of title showing that they are the true owners of that land. if you when you get to second semester doing land transactions, you will look at this under section 59 of the Registration of Titles Act. It's called the indefeasibility principle, right? If at all you have a certificate of title reading your name, then that is conclusive evidence that you're the owner of that property, of that land, right? Yes, you have a title, or most of you know it as a chapa or ina a chapa. Yes, you have a title of that land, and it makes you the owner of that land, unless otherwise. Secondly, another feature is there is an unlimited period of ownership. Yes, unlike leasehold, freehold, you hold it in perpetuity, right? There is no limited period of time of holding it, right? Then 3, leasehold can be converted to freehold. Yes, leasehold, even other types, because you can even convert Mailo to freehold. You can convert customary, so you can convert any other tenure system into freehold. The land, in addition, the landowner has full powers over land and can do anything lawful with the land. We talked about this. You have full powers over your land. You can do whatsoever you wish, provided you do it in a recognition and adherence to laws governing land in Uganda. In addition, freehold tenure cannot be acquired or held by a non-citizen. A non-citizen can only acquire a leasehold on freehold tenure. Yes, freehold is only acquired by citizens, because land belongs to all citizens of Uganda. Then you can only acquire freehold if you're a citizen of Uganda. Non-citizens only acquire freehold, or only acquire leases on freehold land, right? Then lastly, the Registration of Titles Act governs transactions on freehold tenure. Yes, we looked at this. We said that the reason why we are not going to go into details of this type of land is because this land is governed by the Registration of Titles Act, which you're yet to see in your second semester. So that's all we have to say about freehold tenure system. Okay, then let's look at leasehold. What's the leasehold tenure system? This is a form of tenure where one party grants to another exclusive possession of land for a specific period of time, usually, but not necessarily in return for a periodic payment or money, right? Or you can say leasehold can be defined as holding land for a known time frame based on conditions in an agreement between the registered owner and the tenant, right? So leasehold involves a landowner giving another person called a tenantee or lessee the right to possess or control the land in exchange for payment. The owner of the land grants another person undisturbed or exclusive use of the land, usually for a specific period of time. So leasehold is governed by the Contracts Act, because it is a contract. You make a landowner makes a contract or enters into a contract with another person known as a tenantee or a lessee, right? You own this land for a given period of time, right? Land may also be leased from the state to individuals for typical lease periods of 5, 45, or 99 years. In return, the tenant usually pays an annual rent for service under specified terms and conditions. Leaseholders may or may not hold formal contracts with the owner, although it is highly recommended that formal agreements are signed. So we note that a lease starts from 5 years to 99 years. So if at all you enter into an agreement of giving away your land for exclusive possession to another person for a period between 5 to 99 years, that means that you have given out a lease to another person. So the other person holds a lease on your land for a given period of time. So you have to specify the time the lessee or the tenant is holding your land. Leasehold tenure is mostly evident on public land on which they are granted by the district land boards or Uganda Land Commission on behalf of government. Yes, we know that government owns land. Yes, and this land can be given out on lease by the district land boards or Uganda Land Commission on behalf of government, right? It can also be granted on customary, Mailo, and Freehold. Yes, we looked at this when we are looking at Freehold. Yes, Freehold, customary, and Mailo, you can you can create a lease over your land provided you're the owner of that land, right? So those are the characteristics. That's what we should know. Let's look at the features of a leasehold land tenure system. The lessor transfers exclusive possession to the lessee. So who is the lessor? The lessor is the registered proprietor or the landowner, right? He or she transfers exclusive possession to another person known as a tenant or a lessee, right? Transfer is made upon payment of an agreed rent called that premium. So upon giving you that exclusive possession of that land for a given period of time, you have to pay them something in return known as the premium. Are we together? A lease is given for a specified period of time, the start and end of which is clearly stated in the lease agreement. Are we together? Then well, you should also remember this. I mentioned it when I was starting that a lease begins from 5 years to 99 years, right? So under your lease agreement, you should specify the number of years that person or the lessee is to use your land, right? And the date on when the lessee, on the lease, the date on when the lease shall be terminated, right? It is only it is the only form of landholding allowed to foreigners in Uganda. Yes, we talked about this. It can be, all land belongs to the citizens of Uganda, but the exception is other persons who are non-citizens of Uganda can actually acquire land for a given period of time, right? They can only hold land under leasehold, right? A non-citizen cannot be granted a lease for more than 99 years. Yes, this is self-explanatory. Then lastly, it is common in urban areas such as towns, municipalities, and the city where public land is held and managed by institutions such as the Land Board, Uganda Land Commission, and district land boards. I think we mentioned this, right? We're not going to go into details of leasehold and tenure. I must repeat this because you're going to look at it when you're doing land transactions next semester, right? So back to our question that we're answering. You have to give features or characteristics of each tenure system, and you find out which one is the best, and of which I've told you the best tenure system is Freehold for the reasons I've given you, right? Lastly, let's look at Mailo tenure system. Mailo tenure system. When you're looking at Mailo tenure system, what comes into your mind? It is a creature of the 1900 Buganda Agreement. It was a semi-freehold tenure system confined to Buganda Kingdom and part of Bunyoro, mainly in Chibali. Yes, it was established under the terms of the 1900 Buganda Agreement between the Kabaka of Buganda and the British government, right? So under the I know if we remember our constitutional history very well, where we looked at the 1900 Buganda Agreement in details, we must have looked at Article 15 of that agreement, which prescribed for distribution of land, right? Okay, let's look at the agreement. The agreement was intended to achieve the following. The agreement was intended to achieve the following: 1, to maintain political order in the Kingdom of Buganda; then 2, to shore up the position of the Kabaka; then 3, to allow the peaceful imposition of colonial rule. Then I must say this: in case you want central people, the Baganda, to adhere to your your rule on them, just do one thing: just respect their king and keep quiet. Because if you respect their king, then trust me, you're going to get each and everything that you want out of them, right? If I told you, first of all, respect their king. So the colonial government used this as a tool right, used the 1900 Buganda Agreement as the tool, because that agreement sought to maintain the political order in Buganda, putting the king at the most top position, right? Then, in order to allow peaceful imposition of colonial rule. So under the agreement, which agreement was the 1900 Buganda Agreement, half of the land in the Kingdom of Buganda was allocated to the Kabaka royal family and several thousands of Buganda chiefs and notables. Let's go into details of the Article 15 of the 1900 Buganda Agreement and see how land was distributed. We see that 9,000 square miles of land was given to the Kabaka, yes, of Buganda. 350 square miles was reserved for plantations and other private property of the Kabaka still. Yes. 16 square miles were reserved for the Namasole. The Namasole is the Queen Mother. Yes. And 90 square miles were reserved for the princesses and their sisters. Then Abamasaza, all chiefs got 160 square miles per each, right? The three regents of the king got 48 square miles per each. Then the Kamswaga, or the chief of Kochi, got 20 square miles, right? So this is how that land was distributed. Anyways, the rest of the land was allocated to the protectorate as crown land. So we should note that the peasants, who are the majority by the 1900, did not get any land per the 1900 Buganda Agreement. They are not given any land. So these people lived at the mercies of the notables, or privileged people who owned land under Mailo, right? So, so these people who own this land had their land registered and certificates issued to the owners under the Registration of Titles Act, right? So just like we say that Mailo tenure system is a semi-freehold tenure system. Yeah, right now they're telling us part of this land, I mean people who got this land had their land registered and certificates were issued under the RTA. Are we together? The land was granted without any conditions of tenure, but subsequently Mailo owners were prohibited from transferring or leasing their land to a non-citizen or religious organization without the prior consent or authority of the Luchiko or Buganda Council and the governor. Okay. We should note that it's under Mailo tenure system where we find people with two different interests over this type of land. We see the Chibanja holders and the landholders. So Chibanja holders were the peasants who didn't get anything but lived on this land at the mercies of the notables or chiefs who received this land, right? So the Chibanja holders or peasants who had settled on this land as tenants with the consent of the Mailo owner paid Busulu and Envujo. Envujo is commodity rent, so Busulu is land rents, right? So in order to live on that land peacefully without challenges from your landlord, you had to pay Busulu if you were a Chibanja holder, right? Let's look at the 1928 Busulu and Mvujo law and how it came to be in existence, why it was signed, why it was enacted. In the early 1920s, chiefs and landowners increased Busulu and Mvujo to unreasonable levels. The undue burden on tenants led to an alliance of the peasant with the Bataka, or the traditional leaders. And therefore, the Bataka land so this was because the Bataka land rights had not been addressed by the 1900 Buganda agreements. So in the alliance with the peasants, whose labor and revenue had been excessively exploited by the new landlords, both parties staged a struggle of the Bataka movement of 1920s. In response to the above, the British government forced the Luchiko to pass the Busulu and Mvujo law of 1928 to mainly regulate the rights and obligations of the Chibanja or Mailo owners. So why was the 1928 Busulu and Mvujolo passed? It was passed reason being the new landowners under the Mailo tenure system had excessively exploited the tenants, the sitting Bibanja holders, by increasing rents to unreasonable levels. So these people rioted against this. That's why the British government forced the Luchiko to pass the Busulu and Mvujolo in order to regulate rights and obligations of Chibanja holders and their landlords or Mailo owners. So let's look at various provisions made under the Busulu and the Mvujolo. One, the Mailo, there was a provision that if a Mailo owner allowed a person to settle on his or her land as the Chibanja holder was deemed to enjoy an inheritable permanent right of occupancy subject to payment of a fixed annual rent. Secondly, the law set a limit on the fee to be paid on to the landlord. Thirdly, Busulu was fixed at 10 shillings per year plus a merely nominal envujo of 4 shillings per acre of coffee. So we see provisions that if the landlord allowed the Chibanja holder to be on their land, then that meant that the Chibanja holder enjoyed inheritable permanent rights over that land. That meant that even upon their death, their children would claim to be rightful owners of that land under Chibanja, right, under equitable interests. Then secondly, it fixed the annual rent of Busulu to 10 shillings per year and a nominal envujo or commodity rent of 4 shillings per acre, right, or per acre of cotton or coffee. Then thirdly, for a mile owner to evict a Chibanja holder, this land would at least be a moment. I beg my pardon. A Mailo owner or a landlord did not have to evict a Chibanja holder except where the land was required for public purposes, right? Yes, this is similar to the compulsory land acquisition we have in Uganda. If government needs your land for a public purpose, then it has a right to compulsorily take away your land from you, right? And so that was a provision still under the 1928 Busulu and Mvujolo. Then secondly, under what circumstances was a landowner or a landlord allowed to take your land? If at all you are a Chibanja holder who was so reluctant and you did not attend to your land for 6 months and above, right? Then the Chibanja, the Mailo holder or the Mailo owner or landlord would take away your land, but they would only do any evictions upon a court order. All right, they would first of all get a court order before executing any evictions. Then lastly, the Chibanja holder could sell, pledge, or even mortgage their land at will, subject only to condition that he or she had to introduce the new tenant to the Mailo owner, right? So the three provisions which are very pertinent in which were very pertinent in the 1928 Busulu and Mvujolo were: one, they fixed an annual rent of Busulu which was 10 shillings. That's one. Yes, the Chibanja holder enjoyed inheritable rights over this land. Yes, the Chibanja holder would not be evicted save for a few circumstances, one of them being an attendance to your land for a period of 6 months and above, or where that land was needed for public purposes, right? And lastly, the Chibanja holder had a right to sell, pledge, or even mortgage their land at will, provided they introduced the new tenant to the landlord, right? Anyways, so that was the 1928 Busulu and Mvujolo. Let's look at the Land Reform Decree of 1975. It empowered Mailo owners to evict Bibanja holders from their land for economic development. Bibanja holders or squatters who were in occupation of Mailo land were at risk of possible eviction by landlords. They were tenants at sufferance. So in case the landlord needed this land, and by 1975, then they had the right to take away their land without even compensating you, right? You became a tenant at sufferance. Are we together? You became a tenant at sufferance. Therefore, you did not have any rights if at all you are a Chibanja holder. It was only landlords who had rights over their land under Mailo tenure system, because we understand that under the 1975 it were led by, is it Amin? Yeah, Amin led from 1971 to 1979. Yes, and it was the law, and the law was him. So that was the 1975 land reform decree. Well, let's look at the constitution. The constitution under Article 237(8) provides that all persons in lawful or bona fide occupation of Mailo land shall enjoy security of tenure until Parliament enacted an appropriate legislation regulating the relationship between such occupants and the registered proprietors. So let's look at what Parliament enacted. Parliament then enacted the 1998 Land Act, right? Section 3, subsection 4 of the 1998 Land Act provides that the describes land tenure as a form of tenure which derives its legality from the Constitution and its incidence from written laws. It involves holding registered land in perpetuity. It permits separation of ownership of land from ownership and developments of land made by a lawful or bona fide occupant, right? Section 29 gives us or explains to us who a bona fide occupant is and who is a lawful occupant. Let's read section 27 and we try to lay a distinction between a bona fide and a lawful occupant. Okay. Section 27, subsection 1. Lawful occupant means a person occupying land by virtue of the repealed Busula Nevujol of 1928, Toro Landlord and Tenant Law of 1937, Anko Landlord and Tenant Law of 1937, a person who entered the land with the consent of the registered owner and includes a purchaser. So, a lawful occupant is a person who entered on the landlord's land with his consent, with the consent of the landlord, and this person paid the busulu on this land. Are we together? If they were in Uganda, they had to have paid the busulu to the landowners or the landlords. So this made them lawful occupants because they paid busulu. If at all you tell them to bring evidence as to why they should be called, or as to why they claim to be lawful occupants, they can bring receipts which showed that they pay the 10 shillings per year as busulu. So these are lawful occupants. So who is a bona fide occupant? A bona fide occupant. A bona fide occupant, section 29(2) provides that a bona fide occupant means a person who, before the coming into force of the Constitution, had occupied and utilized or developed any land unchallenged by the registered owner or agent of the registered owner for 12 years or more. Right? So this meant that a bona fide occupant is this person who entered on the land of on the landlord's land without their consent, but they have never been challenged by the landlord, right? That's one. Then secondly, they have been utilizing that land, they have developed that land. Yes, then 3, they must have come to that land 12 years before the coming into force of the 1995 Constitution. So that's the difference. Lawful occupant, you came on that land with the consent of the landlord. Bona fide, you came on that land 12 years before the coming into force of the 1995 Constitution and without the consent of the landlord, right? You've been there, you've developed that land, but you've not been challenged, right? So you become a bona fide occupant. Okay, let's briefly look at the rights and obligations of a tenancy by occupancy. So, 1, the tenant by occupancy is required to pay to the registered owner of land an annual nominal ground rent. Yes, which were the busulu. Yes, we have to pay rent. And the Amendment Act of 2004 provides that nominal ground rent payable by the tenants by occupants shall mean reasonable ground rent, taking into consideration the circumstances of each case, and the rent shall be of a non-commercial nature. So this meant that you had to pay rent, but of a reasonable nature, right? Not so much, but not so little. but reasonable, then you would not be affected. That's section 32. A tenant by occupant shall not be evicted from registered land except upon an order of eviction issued by court, right? For mainly non-payment of the annual ground rent. So if you fail to pay if you fail to pay ground rent, then the landlord has a right to kick you out of their land, provided they have a court order for eviction, right? You read these others. Lastly, you should not sell this land. I mean, if you're the landlord or the tenant, you first of all have to first give priority or buying priority to the sitting tenant or the landlord. So if you're the tenant, before selling your equitable interest to another person, you should first of all give first priority to the landlord. And if you're the landlord, before selling your registerable interest to another person, you should first of all give first priority to the land, to the sitting tenant of that land. And in case you do that without their consent, that means that the whole sale or transaction is null and void. That's section 35, right? Section 35, it's null, and the whole transaction becomes null and void.